Good afternoon, Mr. Nierman.
Good afternoon.
Welcome back.
Thank you.
Please make yourself comfortable, and when you are ready, you may begin with your opening statement.
Thank you. Good afternoon again. I know you've had a long day. I'd like to just briefly introduce my high school sweetheart and wife of 31 years, Lisa. We have two amazing adult children, and their support in this is really valuable to me. Our liberties we prize, and our rights we will maintain. Why did the founders choose this as our state motto? I believe they knew how vital it was to remind future generations that the freedoms embodied in our Constitution require continuous effort and vigilance to preserve. Growing up in Central Illinois, my childhood hero was Abraham Lincoln, and as I continue to study his life, I've become fascinated with the courage of the voters of 1860 who elected him as president. Let me explain. In the 12 years prior to his inauguration, Abraham Lincoln did not hold elective office at all. In fact, he lost two humiliating defeats for the United States Senate. Immediately prior to those dozen years, he served one and only one term in the Congress, just 2 years in the House. At the Republican convention, the delegates rejected 12 other candidates who, in traditional sense, had more impressive public service records. In the general election, the contrast was even greater. All three of his opponents had served in both houses of Congress and had served multiple terms in Congress. One was the sitting Vice President of the United States. One was the former Speaker of the House and former Secretary of War. And the third was Stephen Douglas, who had not only served in all three branches of government, but had just 2 years earlier defeated Lincoln in the most famous Senate race in American history. So what did the voters of 1860 see in Lincoln? Well, to us, the answer is obvious because we see in retrospect that he was the only one of those four people that could have held our country together during its darkest hours. But in the middle of the 19th century, voters could only see those qualities in Lincoln prospectively. And indeed, they saw something extraordinary in him that transcended traditional credentials. In short, they saw someone who valued their liberties and their rights so much that he would go to extraordinary lengths to protect them. Today, as you make a critical decision concerning the future of our state, what do you see prospectively? Who will resist the temptation to infuse public policy preferences into judicial decrees? Who will be able to exercise a restraint of judicial power instead of merely an assertion of it? And who will have the courage to appropriately defer to the people's representatives, elected representatives? These are the critical questions and issues for the judiciary today. And how we respond to them will determine what liberties and rights we will have tomorrow. I'll be happy to answer your questions.
Thank you. And we will begin questions with Ms. Conover.
No questions, thank you.
Mr. Bloom?
So I think you're the second applicant who had experience in teaching law. How has that made you a stronger attorney and a better candidate for the Court of Appeals?
Yeah, so as at least some of you know, law school, the curriculum in law school is essentially appellate court opinions. And so in a sense, law professors fly at 40,000 feet looking around the country for the right cases that demonstrate what the law is and how it has come to be. And so having that vantage point and then be able to break those things down for law students has given me a vantage point in one particular area of law, in this case insurance, that has helped me to not only know that field better, but to appreciate the complexity of other areas of the law. and of course I've had the opportunity to teach internationally. Law in a sense is a different language, and to teach students who by and large did not have English as their primary language was a unique challenge, and it was a great opportunity to help them to appreciate not just this new language upon a new language, but to know what the rule of law is in the United States. I think judges have a great opportunity to be great ambassadors for American law and how we have dealt with the rule of law, and I'd love to be a part of that.
Thank you.
Mr. Spies.
Thank you. Well, Mr. Nierman, you and I have lived in the same community for many, many years, and I feel like reading your application and all your supporting materials, I've been peeking through your window. So I've learned a lot about you that I didn't know, and I'm happy that you're here today. One question that I asked another applicant was that within about the past 4 months, a committee of the federal judiciary dealing with judicial conduct has issued an advisory opinion saying that judges should refrain from membership or withdraw from membership in organizations that are deemed to be political or in which the contributors are anonymous. And you mentioned in your application that you're a member of the Federalist Society. Do you think that that advisory opinion, which I don't know that you've read, should apply to you, and whether you would withdraw from the membership in the Federalist Society if chosen to be a judge?
So I have not read that opinion. I know there are numerous judges that belong to the Federal Society, and if I'm not mistaken, also some from the United States Supreme Court. My understanding is that the Federalist Society does not take positions on specific political issues. It is, in a sense, a series of public policy forums. So, for instance, a few months ago, there was a live forum in Des Moines while the legislature was meeting to discuss the changes that the legislature had proposed to this commission. And so they invited 2 speakers. One was the president of the Iowa State Bar Association, who was adamantly against the proposals, and the other was a law professor from Vanderbilt. I don't know much about him. I wasn't able to attend, but those are the important kind of public policy discussions that the Federal Society promotes. In terms of that specific opinion, I'd have to take a look at it and also to see. My guess is that just applies to the federal judiciary, not Iowa, but I'd certainly take a look at it.
Thanks.
Mr. Hoytik.
You mentioned Lincoln in the 1860 convention. He ended up having to work with a number of the other candidates and formed his cabinet out of them. His ability to work across those relationships were what some say made him transformational. The court is a group. You work in panels and you rely on each other. Do you have the ability to agree to disagree? How do you see yourself working well with people when you may reach different opinions?
Yeah, a couple responses to that. When I'm in a team environment, I'm oftentimes the one who's listening. Somebody says, "Oh, we have to do X," and somebody else says, "Oh, no, we have to do Y," and I'm the one sitting there thinking, "Okay, how can we do X and Y and do it better than if we just did X or Y?" So I am just constantly thinking outside the box. How can we look at this from different vantage points and find common ground? Secondly, part of what's going on in our culture is we're having a debate, in a sense, as to how you treat people that disagree with you. And some people think that that's kind of a license to be mean-spirited. Others feel like, I'm going to respect other people no matter how badly they treat me, and I just absolutely endeavor to be part of that latter category. I think having healthy debate is important, and I think collegiality is so very important. And I'd really encourage you to look at the letters that were submitted on my behalf by members of the bar, many of them that I'm often working against. In fact, one of them is somebody that I'd met prior to law school, and we're almost always on the opposite side. But yet we've been able to, a lot of times lawyers are that bridge between the clients to, when there's a resolution possible, that, the clients can't agree, but the lawyers can. And I've taken my relationship with my colleagues very seriously and just go out of my way to preserve that mutual trust.
Ms. O'Brien?
Thank you. Would you please tell us a little bit about the McKibben case versus United United Healthcare? And I mean, that case just, good for you that you took it. And I guess my question is do you think our laws are adequately dealing with this situation, this type of situation?
So in terms of, if I could take those in the reverse order, in terms of the laws, I think that's very much something in the province of the legislature. That particular case was governed under Iowa Code 514J, which provided a arbitration process, and there's a provision where we can have an expedited process. And so that was very helpful. I think it's helpful to both sides. In terms of that case, it was heartbreaking, and yet my job is not to be hamstrung by representing somebody who might die. My job is to get out there and get the information. Go to the University of Iowa Health Science Libraries, look through the journals, figure out what the issues are, find the physician that can submit information to the arbitrator, and do everything I can for that client. And we had a confidential settlement, so I can't discuss that in detail, but that was a case that meant a lot to me.
Mr. Sukup?
Good afternoon, Mr. Nierman.
Good
You
afternoon.
mentioned that you've served as an expert witness. How would you bring some of the experiences to the bench?
Yeah, a couple ways. It's so different being the one who's being asked questions, who's being cross-examined. Usually I'm the one who's asking the questions. And so I think just increased sensitivity to what people go through when they're being forced to go to court. One of the things I think most powerfully, though, I've had the opportunities to testify not just in Iowa but in other jurisdictions, and it's been eye-opening. I got to go twice to Mississippi and testify. We could talk for an hour about my experiences there, how their court system's different, and things that seemed to work, things that seemed to be didn't work. I think we've got that's helped me to appreciate what an amazing court system we do have. It's not perfect, but I did come away with that just really impressed with how we do things here.
Thank you.
Mr. Goodman?
Thank you. Mr. Nierman, we've had a number of judges talk about why appointing judges to, or nominating judges to this position is important. I'd like to hear the lawyer side of that and why you think it would be a better judgment by this commission to appoint or nominate, one or more lawyers.
Yeah. 3 thoughts on that. One is the Court of Appeals has 9 judges, and they're randomly assigned into 3-judge panels. Right now, roughly half of them have been a trial court judge. So on almost every 3-judge panel, we're going to have at least one person who's been a trial judge. Not 100%, but close to that. Some panels will have 2, rarely will have 3. And I think it's really important to just decide, is it important to also have people that have significant experience in business? Is it important to have people that have had varied experiences, such as serving as an expert witness in other jurisdictions? People that have significant experience in academics. In a 9-member team, we can have people that are able to look at things from different perspectives. And certainly trial judge perspective is important, but it's not the only important perspective. We need to make sure that we have more perspectives represented.
Thank you.
Ms. Law?
No questions, thank you.
Mr. Gray?
Yes, Mr. Nierman, thank you. You mentioned that you'd like to become, if you became a judge, you'd like to become an ambassador to the rest of the country, or internationally, for the state of Iowa. How would you be an ambassador in the state of Iowa for our court system?
Yeah, one of the things that I mentioned in my application is this issue of human trafficking. And this is something that I've become very concerned about. And finally, I just said, okay, I've got to do something. And so what I started doing is calling bar associations or legal associations, hey, I'd love to come to your group and present on an hour state law, federal law, criminal law, civil law on human trafficking. And to do this in just a very professional and informative way. And, in addition to the legal knowledge, we're raising awareness. Estimates are that maybe 40 million people worldwide are being trafficked. Roughly 50% of those are women, and almost a quarter of them are girls. And so, as a judge, potentially I would be able to get into some organizations that might say, well, we kind of reserve those spots for judges and attorneys in our organization. And I think that is one of the most important things that I could do, to have someone from the judiciary coming in and telling people what the law is. And, for example, it's amazing to me how many attorneys, even those that practice in civil litigation and more specifically in injury litigation, aren't aware of the federal cause of action that victims or survivors of human trafficking can utilize. So, for example, not only is there a 10-year statute of limitations, and of course, for a lot of people, they become bonded to their trafficker and psychologically such that it takes them a long time to be able to say, wow, I was really wronged. That's not strong enough words, but so that's important. And the other thing is that the suit can be brought not just against the trafficker, but anyone who knowingly benefited from the trafficking. So, for example, if you have a young girl who is trafficked for sex, and unfortunately that's a huge amount, the vast majority of the trafficking, especially in the United States, and a hotel was used, and that hotel knew why they were being paid in cash, then the trafficked person can bring that action against the hotel. And in addition to, one of the significant things about that is sometimes the traffickers are really evasive, hard to find, but you know where the hotel is, and potentially they have insurance coverage, and so there could be some funds there to help the victim or the survivor restart their life.
Thank you.
Ms. Pearson?
No question.
Ms. Stanger?
No question, thank you.
Mr. Berger? Ms. Valentine?
I'd have to object to mine as being answered already, so.
Okay, thank you. Mrs. Sinclair?
No questions.
Mr. Bevel?
I'm following the gray rule, no questions.
And Mr. Horbach?
I have no questions.
Mr. Nierman, we appreciate your being here today, and we wish you very well.
Thank you for your time.